Thank you, my lords. I've discussed with the other council. I'm going to carry on to finish my bit, and then they will have an uninterrupted.
Yeah, okay, that's a really good idea.
Yes, so just finishing off on the judgment so far as unwired planet balancing exercise is concerned. If my lords could go to core bundle 12, page 453. My lords will there see paragraph 33. Some final observations by the judge. And in 33, Roman 1, the judge notes that he sought an advocate to the court to assist, but none could be provided. And that was particularly with regard to infringing competition law. I might have thought that would be the end of it, but what actually happened was that the judge sets out the concerns he identifies in 33 Roman 2, and he sets out the competition law concern at the beginning and concludes saying, not having heard any submissions on the point, my concern remains, but it's not one that can carry any further in this judgment of consequential matters, and I say no more. Would respectfully submit that leaves matters in a somewhat unsatisfactory position, because the judgment as it's written here gives the impression that the judge himself felt that competition law was in favour of publishing lump sum royalties on the basis of an undisclosed self-direction to that effect. But he received no submissions about that, and he doesn't set out his reasoning on it either. But he did think it was important enough to mention. And then going on in Romans 3, he does mention the importance of open judgment in Fran cases. And towards the last line, he does refer to the proposition that legal certainty is enhanced, whereas much of these judgments are published openly as it is proper to do. But with respect...
Just going back to the point about competition law for a
Yes.
moment. I mean, this is perhaps more a question for counsel who are actually in the case. Was there any request from the judge for submissions from counsel about these matters?
To the best of my recollection, there certainly were no submissions, and I don't believe they were ever requested.
No.
He raised on a number of occasions that he was concerned about this aspect, and I think there was an earlier either a letter or a direction that went out that said that he was concerned about competition law, but nobody responded to it.
Thanks very much. Yeah, sorry, Mr. Campbell.
Yes, I was just pointing to the judge's observation about enhancing legal certainty at the end of 333.3. But we respectfully say the result of this judgment didn't enhance legal certainty. It's for the reasons in 34. We did say to the judge, and we respectfully submit to this court, that the judge's approach has been inconsistent with the approach of Mr. Justice Birss and unwired Mr. Justice Miller, because the law was the same, the facts were essentially the same, and the judge should therefore reach the same conclusion rather than a different one. Now, that is the end of the judge's section dealing. He never dealt with unpacked rates in relation to what he called the old law, because he felt that the lump sum payments weren't protectable in the first place, so he didn't go on. He only dealt with the unpacked rates in relation to Bamford, so there's no section of the judgment dealing with unpacked.
Yeah.
So that completes everything I was proposing to say about that. I've been asked to clarify a few points arising out of questions or issues identified by Lord Justice Birss about tables 9 and 10. Largely these are points that I made before in answer to questions, but I'll do them now in compact form and then move on. The first point is that as far as tables 9 and 10 are concerned, as I think I said earlier, we only saw these as tables containing a lot of black boxes apart from our own information. We never saw the full. I said that earlier. The second point I would emphasise is that the entire basis of both InterDigital's and Nokia's appeal is to keep our confidential information confidential. I respectfully submit of the net effect of unredacting all the other information currently redacted, and by that I mean the combination of the entries in tables 9 and 10 and the totals on average. If the effect of that would be to undermine our confidentiality, which my respectful submission it would do, then we would resist it for that extent, to that extent, for that reason. But thirdly, and this is a point I haven't made before, if the court's judgment on this case is intended to offer guidance on a point of principle, would my submission be potentially confusing to make only partial redactions to lump sum payments and unpacked rates based on the identity of the appellants? And to clarify what I mean by that, if parties have positively consented to publication, that's obviously their right, their prerogative, they can do that, we can't stop them. But in this case, the reason why there's all these black boxes is because all these people, to some degree, whether it was just in writing, whether it was instructing counsel, or whether it was actually making oral submissions and following all the way through to appeal, the reasons why these redactions will be made is because someone, the relevant party whose licence it was, whose confidential information it was, did make an objection to the judge on grounds of confidence. And the only reason we don't have all of them now is they haven't all seen fit to incur the expense of an appeal. It can't be assumed.
Well, I follow that point. I mean, in a sense, your first point is a better point because your first point, which I thought was, I think is really the point that both my lord and I were putting to this morning, which is that it seems to me at least that one effect of non-redaction of other people's figures and the totals is that some bright spark is going to be able to work out, at least on an average basis, what the appellant's figures were, and that is damaging your confidentiality. So that you would say, presumably, that as it were, complete redaction is within the scope of the existing appeal.
Yes, well, no, that is my submission.
Yeah. Okay.
So that's what I was proposing to say on that. And then I come to the topic of mistakes, which I'll try and be relatively brief. There is only one mistake. And again, I'm not going to read out what the mistake is, but I will show my lords what the fuss is all about, in case my lords haven't already realised that. And if my lords go to Core Bundle 1, Tab 1, page 21.
Yeah.
I don't know if my lords have got blue or blue box, but it's the words indicated in the second and third lines. That's what it's all about.
So this is the thing, this is the version of Annex 3
Correct.
you were given, in which there was text in red and text in yellow, and then you've added blue boxes.
Correct. Yes.
And the text in red that isn't got a blue box around it is going to be public,
Correct.
but isn't yet public.
Yes. And I should say, my lord's got the blue box format. We no longer maintain. Does my lord see a blue box that's 4 lines up from the bottom?
One after the yellow number.
Yes.
Yeah.
Yes, we don't maintain that one. It's for reasons I don't need to explain. But it's the blue box in second and third line. Now, it's not disputed by anyone that these words are factually incorrect. And had it been in dispute, I could take my lords to the agreement itself in the sub-bundle 2, tab 26. So why did the judge decline to correct it? Well, go back to the judgment and see the judge's self-direction on this point, and it's in Core Bundle 12, page 447.
Page 447.
Page 447, yes, this is the, it starts at paragraph 24 at the bottom of the page. And as the judge correctly notes, normally third parties have no right to seek to engage in the drafting of judgment that's handed down and is final. Now, paragraph, the rest of that paragraph is a footnote 26, if my lords see that. The judge, in his footnote 26, says, in this case, the errors referred to are several orders of magnitude less significant. In terms of classification, these sit just above the trivial and can properly be called minor. With respect, the judge must have meant just above the trivial in relation to the judgment, because it's not clear why misstating important terms of a commercial contract would be just above the trivial from the perspective of the parties to that contract. And then at paragraph 25, the judge sets out his test three-part test. We do respectfully criticise this test as unnecessarily complicated. The correct test in our submission should have been, if the court is satisfied on the balance of probabilities, there is an error, it should be corrected.
That's how the slip rule operates.
That's
That's how the slip rule operates.
yes, yes, absolutely. Slip rule, yes, it doesn't have these three parts to it.
I mean, speaking for myself, if you come to me, I've written this judgment, and you come to me, and all the parties were agreed, and the non-parties were agreed that the relevant passage was there by mistake, I'd have simply deleted it.
Yes, and that's precisely what.
That, and particularly Little Roman 3 is just that's imposing a completely a test that doesn't make any sense in this context.
Presumably, just to make sure I've not misunderstood something, the reason that we're looking at a judgment rather than a draft judgment is because you didn't get the draft judgment. So you'd have had a chance before the judgment was handed down.
No, the two different judgments. There's substantive judgment,
Yes.
and then there's this one called the consequentials judgment.
Yes.
What happens to substantial judgment?
Did you have a chance before? Was a draft of the consequential judgment sent round to people for typos, and did that include you?
No, there was two different versions. There was the typos only version with everything in it, which went to Appellant and Optis.
Yes.
And then we had a second version.
Yes, but not you is the point.
Yes,
I'm
not
trying to help
not
you,
us.
Mr.
So far as the main judgment is concerned,
Yeah.
you never had a copy of the main judgment to comment on in draft because you were non-parties. Did you?
Well, I want to give the correct answer to the question. The correct answer
you
is
do.
there was two versions of it. There was the parties only version with all the confidential information in it. And then there was various versions specific to each of the third parties.
I understood that, but
And
the
we
point
got
I'm
that.
trying to get at is whether you, at the time when it was in draft, subject to the embargo, did you have Annex 3 so that you could have spotted that there was an error there that you would have said to the judge? Everyone else is shaking their heads, by the way.
Yes, even I know the answer to this one.
So even if you don't know the answer to the question, they do.
Yes, no, even I know the answer. The answer is
it's
Susan.
just sort of- it happens all the time. The parties will say, you said this in paragraph 427. It's wrong.
Yeah.
And most judges will, especially if they're agreed that it's wrong, most judges will correct it. And it doesn't, so not even under the slip rule, it just corrected as a typo.
Yes.
But I'd say, yeah, okay, got the point.
Yes, as soon as we saw Annex 3, we objected to it. And we've objected to it at least 4 times to the judge. So that's the answer to that question. Yes,
So that's the only mistake that you're relying on. This one mistake.
this
in
one is
Annex 3.
correct, yes.
Okay.
Yes. And I think my Lord's ahead of me. We said the third limb of that doesn't make any sense because, even the second part of that, entirely immaterial to the judgment. I mean, suppose it was the correction so important the judgment is very material. That's not a reason just to ignore it, is it? Anyway, I'm not going to show everything on it. I'll just show that there was evidence on this. I'm not going to go through each of the 4 attempts we made to get the correction made, just the first one, which was some actual evidence from a Miss Mattis witness statement. Again, I won't read it out, but I'll show it to the court.
Yeah.
It's Sup 1, tab 4, page 13. And do my Lord see paragraph 19? So the significance of paragraph 19 of this witness statement, and the date of this is actually 6th July 2023, is pointing, it's actually the mistake, as it says, I do not believe this information accurately reflects the terms of the licence, and licensees may be therefore using a false impression. So we did have evidence in support of the correction. And then we had the oral hearing on 24th July 2023, when I made oral submissions about this. That was the second time. We don't need to look it up, but it's up to tab 16, page 301 of bundle, page 147, line 25 to page 148, line 13. And then we had a draft consequentials judgment on 7th of August 2023. But this was a draft version of this judgment, the judgment under appeal. It didn't show what had happened to our submission on Annex 3 to the substantive judgment. The judge, however, did make an order, and if the Lords go to sub 2, tab 17, I won't spend time, I'll just show it was an order. Sub 1, tab 17. The judge made an order requiring us to put in various submissions, and this included some submissions about the mistake. If my Lords, if sub 1, tab 17, page 342, fourth box down, the 12th of September, we had to inform Optis and Appellant any information found as confidential. So we did that as well. That was the third time we tried to get the correction made. And there was then a draft order.
So you said, I thought you said 12th September said something about a mistake, but it doesn't. It says something about confidentiality.
Yes, but that was why one of the reasons why we said it should be confidential. You know, we included it in response to that. So we sent out another lot of submissions about this. Now, we then had a letter from the judge, and this is next tab, tab 18. And this is a letter from the judge to a number of parties. Towards the last full paragraph, the judge will list a further, and hopefully final consequentials hearing for 18th and 19th December 2023. Last paragraph, on the last two lines, the judge wants to be clear this hearing be attended by representatives of Optis and Apple only, and the non-parties who have, as a matter of convenience and justice, been permitted to address the court will not be attending. So we heard there was this other hearing that we weren't allowed to attend. And then the judge sets out various concerns, and when he refers to certain non-parties, I think that refers to the appellants. Romans 1, 2, 3, 4. Point 4 is the judge had benefited from the input of these non-parties, and that term is used deliberately. We consider any concerns that remain can and will be dealt with by submission from Optis and Apple in the future. So we had that letter, and we weren't allowed to go to the December hearing, but we then heard that the consequential judgment was about to be handed down, and we were concerned that our confidential information was going to be published imminently. So then I wrote a letter to the judge, and I'm not going to go through it all. It's in tab 19. And this points out, this letter was actually our fourth attempt to get the correction made. First attempt being Julia Matters, second was the oral hearing, third was the various submissions. And if we'll always look at the bottom of page 347, the correction we wanted made was actually put forward before the court on our behalf by Apple, which Lords see. But then it seemed that it was going to be published after all, so that's why we wrote that letter. And we never had any reply as such. All we do get is from the judgment itself an indication as to what the judge did. And what the judge did is at Core Bundle 12, page 564. Sorry, no, that's not. It's 55.3. That's the reference. It's yes, 464. And in 55 Roman 3, the judge says there were various other corrections made to Annex 3 which fell within Class 2. Annex 3, to be clear, is a schedule that I compiled from the comparables themselves. It was not based on any draft provided by the parties. I exercise my own judgment that descriptions of comparables, and I do not consider it appropriate. Now that the judgment has been handed down, to reconsider Annex 3, matters might be different. There was some material resonance, sorry. The error is apparently identified in Annex 3 in the conclusions of the body of the judgment, but there are not, and I prefer to leave Annex 3 untouched by what are no doubt intended to be improvements emanating from the parties, from the Optis Apple counterparties. So the judge didn't feel it was appropriate, now the judgment has been handed down, to reconsider, but we tried 4 times to make the correction before it was handed down. Yeah. And then the reference to some material resonance, the errors, that's not the same test as the judge's self-direction.
The judgment that's handed down that's referred to in that isn't the consequential judgment, is it? It's the original judgment.
Yes, it must be the full one, capital J. I think the judge says he uses the term judgment to cover both of them, but yes, it's obviously the previous one, not this one. And the judge doesn't really explain what the material resonance test is either. But on the face of it, he seems to be saying that the errors in Annex 3 generally made no difference to his conclusions. But if they made no difference, then on the judge's test, why not simply make the correction? There's undisputed evidence of the fact that it was simply wrong. So to draw this to conclusion, and I'm sure my Lord has heard quite enough from me, we say that the judge applied the wrong test. He set out the wrong test and then applied the wrong test. And our primary position is, as we say in our grounds of appeal, this information should not be published at all. But if it is to be published, then we invite the court to correct Annex 3 in the manner indicated.
Okay. Thank you.
Thank you very much, Robert.
My Lords, I act for Qualcomm. I need to make a few supplementary points in addition to what Mr Campbell has said. Of course, I'm not going to duplicate or repeat anything that he's said. We support all the points that he's made. In particular, on the unpacked figures in tables 9 and 10, we've got the same position in relation to those. I need to make points on two issues. The first is an aspect of the judgment in Annex 3 that specifically affects Qualcomm, that goes not to unpacked rates, but to actual per unit rates on the face of the licence between Qualcomm and Apple. And the second is as to this question as to what the scope of the arguments made on appeal is that my Lords have raised in the course of submissions. That is a point that actually particularly affects Qualcomm. I need to show you some of the history of how these appeals came to this court. With the greatest respect to the learned judge, there has been complete procedural chaos in these appeals, and that has been, and the consequence of that, one consequence of that has been the scope of the arguments that the parties have been able, the third parties have been able to make in these appeals. And I think when I show you what's happened, you'll understand exactly why appeals come before you in the way that they do today. Okay. But let me first make this point about the specific Qualcomm point on the per unit rates that comes out of the judgment. So the issue, in a nutshell, is that the judge has refused to redact the specific dollar per unit and AV ad valorem rates agreed between Qualcomm and Apple in their current license agreement. So he's redacted our lump sum, the lump sum consequence that he says is produced by the Qualcomm Apple license, but he's refused to redact the per unit presentation of those rates. And it is an a fortiori, we say, version of the point made about unpacked rates, because where the rates are stated on the face of the license, anyone who can see them knows that is actually what Apple is paying Qualcomm. And so those figures are of even greater commercial sensitivity than unpacked rates from a license, if anything, because we know that they're accurate, because we know that's what the agreement says. Let me show you where they are stated in the judgment below. So it's core tab 10, and it's page 424. So on page 424, this is part of Annex 3, which is the judge's analysis of the various comparables that were before him at the trial. So we're interested in the Qualcomm a row of that table. So halfway down the page, you see Qualcomm, and in the right-hand column, there's a description, and most of it is not confidential. No confidentiality is claimed. And the first thing I'll just draw to your attention there is the second paragraph in that right-hand cell as to the license period. So I can tell you that the license period has been extended, as envisaged in that provision, in that paragraph. So we're talking about a current license agreement between Qualcomm and Apple. It's not and that's publicly available information that license agreement remains current. And the points that are an issue are extremely small in terms of volume of redaction, but extremely important. And they're towards the bottom of the tab, the bottom of the row rather. You see there's a line starting the consideration for the license. Yeah. Yes, and then you see the first indented paragraph stating the per unit royalties. And it's those two figures that we seek redaction of, and that the judge appears to have refused redaction of, although I'll show you it's actually really not clear at all whether he actually turned his mind to them in the judgment. And then you see in the following line that that another aspect of the consideration is redacted on the other hand.
The yellow bit's redacted and the
So it's all a bit weird. But we can see what the judge has then redacted is his conclusion, his workings based on those figures. You can see that at table 11 if you turn back to page 400 of the bundle. So this is table 11 that sets out the judge's analysis of the implied stack value based on all of the different comparables he had. And again, we're looking at the Qualcomm row, so second from the top. And you see that materially all of those figures there are in yellow text, so they're redacted to the rest of the world, and they'll stay redacted. But what that figure in the first line there for royalty payment is the judge's analysis of the products of those per unit rates. So he's redacting the lump sum, but he's not agreed to redact the underlying per unit rates. And the underlying per unit rates are the really valuable commercially sensitive information. This is valuable and commercially sensitive too. I'm certainly not pushing back against the redaction of that. But the per unit rates is absolute gold.
You don't have to engage in reverse engineering.
No, there's no.
From this, you'd need to engage in reverse engineering, but if you've actually got the rates, you don't need to engage in reverse engineering.
We skip all those steps, yeah. So if you could imagine a more paradigmatic example of commercially sensitive information in a license, it's impossible to conceive of, my lord.
The judge must just have missed it, wasn't he?
Well,
I mean, is there anything in the judgment that suggests that he turned his mind to it?
yeah, so let me show you. I mean, the reality is that it does not fall in any of his classes of information as identified in the judgment. And so I find myself in difficulties showing you exactly what he said because it's not clear to me what he said. But let me show you what I think comes the closest to analysing this point. So I think it's probably closest to Class 6 material. If we look at Core Volume 2, tab 12, and we start at page 464 of the bundle. Now, you see that Class 6, from the heading there, heading F, you see Class 6 redactions relating to ad valorem licenses. I mean, this isn't a pure ad valorem license, you know that, but this seems to come closest in reasoning to looking at these kind of points. So paragraph 54 makes a point about lump sums in Optis comparables. This is an Apple comparable, says that lump sums should be redacted. But then 55, as regards other aspects of the licenses, I don't consider there should be any redactions to the ad valorem rates contained in the various Optis comparables. That's because this information was not confidential. And the judge goes on to explain that they were headline rates. They were the product of the application of headline rates that were published by Optis. And so licenses reflecting your published headline rates, his reasoning goes, can't be confidential in terms of the royalty rates. That's fair enough, but that doesn't obtain at all in relation to the Qualcomm Apple license, which is an individually, unsurprisingly given the parties involved, individually negotiated license that has got nothing to do with headline rates. And there is evidence before the court, I won't take you to it, so let me just give the reference for the transcript in case you want to look. It's at Supplementary Volume 1, Tab 2, and also from Apple, Supplementary Volume 1, Tab 5, page 72, paragraph 11. There's, unsurprisingly, there's evidence before the court that this material is indeed confidential. So that point doesn't stack up.
Just to be clear, part of the point you're making is that, I mean, this word ad valorem is the percentage. It is, you are saying we should redact one of the percentages, so it is an ad valorem rate, but it's not in an Optis comparable.
No.
It was a license with Apple.
No, it's not. I'll show you a bit of the judgment about the Apple licenses in a minute. But as I say, we've looked at the judgment to try and find where he analyses this, and we can't find it. And then the learned judge's other point is at Roman 2, nor do I consider that there should be any redactions to per unit rates. These rates are only significant when volumes of products sold are considered, and these volumes are not published in the judgment. That, with respect, that just doesn't make sense at all because of this point, that it's the per unit rate that's the real gold dust. Because if you're going as a licensee to negotiate with a prospective licensee, to negotiate with a licensor, it's much easier to go knowing, well, X paid Y Z dollars, than to say, well, X paid Y Z $100 million, and then I need to figure out how many units that covered, what the value of the cross license was, and so on, because you just skip the unpacking stage. And so if that's the reasoning, then it just doesn't add up at all. Now, just to make sure that I've properly shown you all the bits of the judgment that could be said to be relevant, let me also show you what the learned judge says about class 3, which it relates to the Apple licenses. So if we go back in the judgment to page 449, you see the heading introducing class 3, and the most relevant bit of that is the analysis of the degree of weight to be given to confidentiality. So Mr. Campbell's already shown you these, so I'm not going to take you through these paragraphs, but if I just pick up the key punchlines, if you look at 31 Roman 3 at the bottom of page 450, it says the class 3 material is, I accept, confidential. And so this is the lump sum royalty information that he's saying is confidential. And the learned judge makes the point made by Mr. Justice Birss, who then was in UP, about why that confidentiality arises, the asymmetry of information point. But then he goes on at Roman 4, I accept that this is a factor pointing towards redaction of the class 3 material, but it's not a strong factor. So confidentiality is not a strong reason, apparently, to redact material for the following reasons. And then A is really important. So the class 3 material in this case is not, in my judgment, especially commercially significant. And then it is, as Annex 3 shows, that's the bit with this information in, very dated. Then he goes on to explain that by reference to various other licenses that are not the Qualcomm Apple license. And he says at the end of that paragraph, I accept that as regards current licenses, the case for protection is materially stronger. So the judge, on his own reasoning, should have been accepting that the case for protection of this information in the
As at the date of this judgment, even before any extension, the 2-year extension, your licence had 18 months to run.
Yes, it did.
It was a current licence.
Yeah, it's at all relevant times. It's been a current licence, and so with greatest respect to the learned judge, on the basis of his own reasoning, even assuming he didn't get the law wrong, on the basis of his own reasoning, this material should have been redacted. And we know, I mean, Mr. Campbell has taken you, for example, to paragraph 42 of the InterDigital judgment, where he said that, Mr. Justice Mellor said that the most valuable information is royalty rate terms in current or recently expired licenses. So you couldn't imagine a more obviously commercially sensitive set of material than these two extremely limited figures of which Qualcomm seeks redaction. So for all of those reasons, in my submission, it's as close as you get to a commercial sensitivity no-brainer. But that's even before one starts thinking about how this information actually plays into the analysis in the judgment. Because, as my Lord Justice Birss knows, of course, better than I, as it turned out, the Qualcomm licence royalty rate terms were relevant to even the first instance judgment only in a very moderated and indirect way because of the reasoning that the trial judge applied, and I'll show you what I mean by that. And of course, in the Court of Appeal, my Lord Justice Birss's analysis took the royalty rate under the Qualcomm Apple licence completely out of account. So it's not actually relevant at all to the Court of Appeal judgment, which I dare say, again, with respect to the learned trial judge, is likely to be of much more enduring and enduring significance to in future FRAND disputes. So the peripheral relevance of this material, which is one of the factors that my lord identified in UP as relevant on the balancing exercise approach, is a further strong reason why this material is doesn't need to be made public. I probably should explain that to your lordships by reference to the judgments here and below, because I know my Lord Justice Birss will be aware of this. So let me take you to it via my Lord's judgment in the Court of Appeal, because that's the most accessible description of what the trial judge did. So that's Core Bundle, tab 2, volume 2 rather, volume 2, tab 13, page 516. My Lord Justice Birss explains at paragraph 105 that the judge's approach to Qualcomm was essentially to conclude that it was not a good comparable. And then Lord Justice Birss goes on to explain why that was. And my Lord then says that what cannot be justified, so if one starts 6 lines or so into the paragraph, what cannot be justified is the adjustment the judge decided to make for Qualcomm, inserting the figure which was the average of the AV1 column, we'll have a look at that in a minute, having decided that the Qualcomm figure had to be replaced. His own comment that it would make a statistician blush makes the point. And then my Lord explains why what could have been done instead. But then what really matters for practical purposes for this appeal, first sentence of paragraph 106, however, the approach to Qualcomm does not matter now because neither party sought to include it in the analysis. So by the time of the Court of Appeal, the Qualcomm Apple license is for the birds in terms of the methodology. And that is reflected in what my Lord actually did in terms of the methodology. And just to show you that, that's on page 521, paragraph 131, where my Lord says, turning to the Apple licenses, I'll ignore Qualcomm and 2 others. In terms of the judgment that, again, with respect, everyone's likely to be reading for the analysis of what a FRAND license is between these parties, the Qualcomm license terms are completely irrelevant. But even on the judge's analysis, the actual figures in the Qualcomm license were of extremely peripheral relevance. And can I show you that by picking up the first instance judgment, at Core Volume 1, Tab 10, and pick it up at page 404. So page 404, and this is table 13. And what this table does, I think it might be helpful just to reorient the court. What the table does is it looks at the implied total stack values taken on the basis of each of the comparable licenses. And so what the trial judge is trying to do is look at the comparable licenses and say, well, look, if that was the true value of the stack, what would it mean for what the total stack would be worth? That's the starting point. And you can see more of it than I can, but you see that the Qualcomm license appears in the table 19. But then what's important for this purpose is what the judge decides to do with the Qualcomm figure, because effectively he decides, instead of using the figure taken from the Qualcomm license, he instead uses in his analysis, as you saw in Lord Justice Birss's decision in the Court of Appeal, he uses an average of all of the implied stack values in place of the Qualcomm license value. I'll show you where the judgment shows that. You can pick that up at Romans 6 on page 405. So the judge says, the judge comments on the effect of the Qualcomm input on the overall average.
So he doesn't exclude it altogether, he reconfigures it.
He reconfigures it, yeah. He substitutes for the Qualcomm figure an averaged figure, and that has a couple of consequences. Look, even if the learned judge had used the Qualcomm figure as a direct input into the average that he derived and that he used to assess what a friend rate was, even if he'd done that, the per unit rate would be very distant from the figure that was actually of core relevance to the judgment, because you'd have to take a per unit rate, convert it into a lump sum rate, change the lump sum per annum rate into an implied stack value, and then use it as an input into the average. So there are lots and lots of steps, even from the per unit rates, even if he'd done the same with the Qualcomm license as he did with the others. But actually he didn't even do that, because he didn't even use the output of his analysis of the Qualcomm license, save insofar as it was all muddled in the mix with all the other licenses in producing the averaged figure that he used instead. And so really to say that the Qualcomm license figure per unit figures are of peripheral relevance oversells their relevance. They're really just not, they are really so far removed from the core reasoning of the judgment that they're not of any relevance or utility at all to the reader. And as I say, that's a point that was identified by Ms. Justice Birss, who then was in UP, as relevant to the balancing exercise. So for all of those reasons, because these are the crown jewels, they're the gold dust of commercially sensitive information, because it's a current licence, and because it's extremely peripheral material to the judgment, for all of those reasons, then we ask for those two figures in Annex 3, small figures but of mighty importance, to be redacted. That's what I say about those two figures. I need to say something now about the aspect in relation to the arguments made on appeal. And in order to explain to you how those arguments have developed, I just need to show you, and I won't take a long time over this, but I do need to show you how this appeal has come before this court, because I think it will be relevant to your Lordship's assessments. So the point that's made in the Optis Apple note, which we received on Monday in relation to Qualcomm, is that there are a number of bits of the judgment that the judge has not agreed to redact, that if they were published could be used to reverse engineer information relating to Qualcomm's lump sum, which the judge has agreed to redact. Yeah. So it's a particularly forceful variety of the point that my lords were discussing with Mr. Campbell about the totals in tables 9 and 10, and I'll show you that it applies with particular force to Qualcomm. But let me show you why it's happened the way it's happened. So if we look at Supplementary Bundle 1, tab 16, and we go to page 305 of the bundle, I'm going to show you, to frame this, an exchange that between counsel for Qualcomm at first instance and Ms. Justice Marcus Smith at the confidentiality hearing in July 2 years ago. Now, counsel for Qualcomm at that time was Mr. James Flynn, King's Counsel, who sadly is no longer with us, and so that's an explanation for that. So if we just pick this up on page 305 of the bundle, page 163 of the transcript. In essence, Mr. Flynn throws himself on the court's mercy to say, look, we do not know what we don't know in relation to the redactions, and we need the court's help to know whether there are other things we should be concerned about. So line 12 of page 163, Mr. Flynn says, the only point really, my lord, and I can't do the details because I don't have them, and then refers to paragraph 483 Roman 6, which I'll show you in a minute. Mr. Justice Marcus Smith said yes, and then Mr. Flynn says, this is where you explain what you've done, what you propose to do with my client's information. What I understand is that means that the information will feed into one or other of your previous tables. You have table 11, which I can't see any of, and table 13, which I can only see one line of, and your lordship has given an indication. But what I don't know is whether if you compare the bottom lines of those tables, you would see totals, and by some fairly simple arithmetic, you could work out what your lordship has actually decided should not be revealed by the judgment. And then the learned judge says, most excellently, a point that is going to have to be bottomed out when we've actually worked out what is and what is not removed. And then 2 lines further on, I certainly will not be putting out this judgment without ensuring that people are heard on it. Mr. Flynn says, just make an additional point, and then a couple of lines further down. In a way, I'm throwing myself on the mercy of the court to say, can we not have a situation in which things are compared where probably even I could work it out? Mr. Justice Marcus Smith says, you will not need to be thrown on the mercy of the court, Mr. Flynn, because what will happen is there will be a process, as we discussed this morning, where, in the light of my judgment, Mr. St. Ville, who is counsel for Optis, will prepare a removal of redactions which will be run past the Apple team. They, I will anticipate, will be alive to the concerns that exist. I hope they'll raise with me, before they take to any third party, instances where Homer has nodded, where are, from the figures that I have indicated are being deleted, a risk of either other references or back-bearing, by which the learned judge means reverse engineering.
Reverse engineering.
Yeah. So that is the assurance you will have. After that, it will then go to you and you'll be able to see what is said. At the moment, I don't think you need worry. But I do not want you to think that's any kind of, it should be SOP, I think. SOP, say you will get the outcome and you can read it as an open judgment and weep. That will not happen. There will be a process. And then it goes on in similar vein. So that was the promise that we had from the learned judge at the hearing. We were still worried about it. Qualcomm was still worried about this. So we wrote to the parties to raise the point again after the summer. So you see earlier in the same bundle, supplementary 2, tab 31. And if you go to a letter that starts on page 500,
Yeah.
so this is a letter from Quinn Emanuel, my instructing solicitors, to the parties, solicitors for the parties in the action, in September 2023. And I'm not going to take you through it in detail, but the relevant section is on page 503, starting at page 16. And it cross-refers to what Mr. Flynn said at the hearing before Mr. Justice Marcus Smith. So paragraph 16, the judge did seek to address in the consequential judgment our client's concern as to whether there could be data which, if left unredacted, could be used to reverse engineer information. And then at paragraph 17, that concern expressed by Mr. Flynn at the hearing was repeated. And then he says, Mr. Flynn, KC, raised the concern that it may be possible, given the information in paragraph 483, to use, which is currently redacted such that Qualcomm and their legal representatives cannot see it, to use simple arithmetic to calculate the redacted figures contained in table 13, the confidential Trial E Judgement. And then the letter goes on to explain why that is in relation to particular bits of paragraph 483. And the punchline is really paragraphs 21 and 22. The figures in table 13 and paragraph 483 remain redacted to our client and its legal representatives. Thus, we cannot state with any certainty whether the above is accurate. However, the judge assured Mr. Flynn, KC, at the consequentials hearing that there will be a process for bringing to the court's attention any possible means by which redacted information could nevertheless be identified through back-bearing, and that there would be an opportunity for our client to be heard. And then, in that regard, we're grateful for the judge's assurances and for Wilmer Hale bringing this to our attention and the attention of the judge. And we say we're reliant on the vigilance of the court and of the principal parties. So it really couldn't be clearer that we've got no option but to rely on the court and on the parties, who are the only ones who have seen all of the information. But what happens then? Well, Mr. Campbell has shown you what happened then, was that we the third parties received a letter from the trial judge to say we weren't allowed to come to the December 2023 consequentials hearing. We couldn't be heard. So contrary to everything that we'd understood about how the process would work, we weren't allowed to go along to that hearing. Further procedural confusion followed when we thought that an unredacted version of the judgment was about to be handed down. So we had to make a protective application for permission to appeal to try and stop that from happening. In the event it didn't happen, but we didn't even have an order at that stage that we were able to appeal. Eventually, we did get an order in June 2024, which is the order that's now under appeal. But let me show you what that order did. So it's at Core Volume 2, Tab 11. So if you look at paragraph 2 of that order on page 429 of the bundle, you see the only information which will remain redacted will be that highlighted in yellow. It was contended that the information highlighted in red should be redacted, but those contentions were rejected. But, and this goes to a question that I know Lord Justice Birss asked earlier in the week about what Annex 2, what the content of Annex 2 was. The answer is that there were different Annex 2s for the different third parties. So we never got to see all of the information that would be unredacted on the court's approach. We saw our yellow information, which is obviously fine, and we saw our red information, but we didn't know who else was potentially appealing. We didn't know what other information lay underneath the redactions that were not lifted for us. We just couldn't have appealed. We couldn't have sought permission to appeal or appealed the unredaction of information that we had never been shown. And now it turns out, and we've learned thanks to the helpful note from Optis and Apple, regrettably we only got it on Monday this week, we've now realised that actually there's lots of Qualcomm specific information that if unredacted would enable the lump sum to be reverse engineered. And I think there are 7 instances in the Optis Apple notes specifically affecting Qualcomm. We agree with every single one of them. I don't know what numbers lie underneath those redactions, and so this was news to us on Monday. Can I just give you a couple of examples of the sorts of points that have arisen, just to make sure that I've communicated it properly to my Lord the Chancellor and Lord Justice Zacaroli, because I anticipate Lord Justice Birss already knows exactly what I'm talking about, having studied the judgment in detail. But I'll just give you a couple of examples. If you go to Core Bundle Volume 1, Tab 10, page 405. So page 405, and this is part of paragraph 483 of the judgment. You might recollect that Quinn Emanuel letter asked what lay beneath the redactions to paragraph 483. So our concerns have eventuated or materialised. So if you pick it up at Romans 6, and the second sentence starting on the 3rd line, you see it says the royalties payable by Apple to Qualcomm comprise around black box of the total. Now the point there, this appears to be a percentage figure. The point there is that if the court were to unredact the total in table 13 and to unredact that figure, then it would be extremely easy to work out what the lump sum payable by Apple to Qualcomm is according to the judge's analysis.
Do you know why you weren't told that? I mean, I was slightly puzzled by the fact that this has come out in the way it has.
Yes.
Why isn't this Qualcomm confidential information that would have been in the red thing that you were given?
I've wondered about that too. It's not really a question for me, but I would make 2 points. The first is that I think it's because the figure derives from the total, and the total's been regarded as no specific third party's information. And the second point that I would make is that Optis and Apple and their solicitors have faced a Byzantinely complex exercise of redacting this judgment, and have had to produce so many different versions of the redacted materials, and have done it, so far as I know, uncomplainingly and over a hugely long period of time. And although we would really have appreciated knowing this knowing about this before Monday, one's got to be sympathetic
And the
to.
point you just made to us is precisely the point that counsel for the parties make on page 8 of their note. In really, each of the references to to page 405, which is the one we're looking at.
Yeah.
It makes the point, certainly the second two make the point, that if the information were disclosed, it would be straightforward to calculate Qualcomm's royalty, since the totals aren't maintained as confidential by the judge. It's precisely the point you just made. So
Yeah.
the point's made there in spades, really.
It is, absolutely.
Twice
Yeah.
over.
Yeah, and really, it's just another way of getting at the confidential information that should have been redacted. And I respectfully support and agree with all of the points made that affect Qualcomm, which are between pages 7 and the bottom of page 8 of this note. And the point that I felt I needed to address with your lordships, given the questions that you asked this morning, understandably, is why these points weren't directly challenged in our appeal, and I hope that your lordships can now see how that's come to be the way that it is,
Well,
and it is.
the more developed point, if I can put it that way, that both Lord Justice Birss and I put to Mr. Campbell this morning, which is a point about the impact of disclosure of other people's confidential information on you, and by I mean one of you, appellant, is something else that you couldn't possibly have actually articulated, because so far as you're concerned, all these figures are blank, and you don't know which ones are going to come out according to the judge's analysis. So far as other people are concerned, you don't know which ones he's saying are yellow and which ones he's saying are red.
Yeah. That's absolutely right, my lord. And the point just sounds with particular force in relation to Qualcomm because of the way that our licence is singled out in the analysis. Because the point that my lord made to Mr. Campbell earlier is that if you've got a number of black boxes in the analysis, it might still not be possible to work out what's in each of the black boxes. But here, in the Qualcomm analysis, in paragraph 483, there is only one black box in each instance, and it's the Qualcomm lump sum.
Yeah, got you. Okay.
So for all of those reasons, we would ask that the redactions to 483 are maintained as proposed by Optis and Apple, so that they don't indirectly reveal Qualcomm's lump sum.
Sure.
I'm very grateful.
Thank you very much.
My lords, I appear for 3 counterparties, Huawei, Google and LGE. And my lords, if I may first address you on the scope of appeal, and there may be a degree of overlap with what my learned friend Ms. Abraham has just said, but I'll try clarification. But my lords, I wonder if I can actually start by looking at the appeal notice, controversially.
It's always a good idea, isn't it?
Which is in core 1, tab 4, my lords. And in particular at page 67. These are, this is the notice for all 3 of my lords. And the permission to appeal sought is against the following paras of the order, namely that the only information which will remain redacted from the less redacted trial E judgment will be that highlighted in yellow. And so the order that is being appealed is an order not to redact information which has been contended to be confidential. And my lord, if I can just turn to my grounds at page 78. One sees at the end of para 1 that whether unpacked ad valorem rates are confidential has been purely a question of whether the lump sum rates are derivable is an error of principle. That's a general error of principle. And then 2, any information about the levels at which a counterparty has negotiated alliance with Optis is information that is confidential and so forth. At 3, The judge accordingly erred in principle by treating those rates as failing to treat those rates as confidential in their own right. So that's ad valorem rates generally. And my Lord, at 4, further in any event, the judge was wrong and found that publication of Class 5 materials, and in particular the unpacked ad valorem rates in Table 9 of the judgment, would not undermine the effectiveness of his order that the lump sums be disclosed. Remain redacted, I'm sorry. And then finally, at 6, the unpacked ad valorem rates are information about the Appellant Optis counterparties license agreements with Appellant Optis and are therefore confidential. So, my Lord, my client's grounds were couched in general terms to the effect that the judge had erred in principle by his treatment of unpacked rates. And accordingly, my first submission is that I would respectfully submit that all of the unpacked rates and their disclosure is something which falls within the remit of my appeal. My Lords, if I'm wrong about that, and my appeal is somehow limited to the protection of my own clients' unpacked rates, then my submission is that implicit in any such appeal is that if there is information that would be published in the judgment that adversely affects that, then that is something which itself is within the scope of my appeal by that implicit effect on the information which plainly is the subject. And I would submit that this court has the wherewithal to render my appeal, if it's so limited and if successful, also effective.
If I'm slightly worried about just the breadth of that. I understand completely the point you make that if the publication of someone else's rates allows for information to be derived about your rates,
Yes.
then I can see why you say that I'm not going to decide the point on the scope of your grounds, but I can see why you say that's within your asking. But what if, and I don't remember, but I have a funny feeling there were more third than this at one point than there are now.
That's correct. There were a number. Indeed, I in fact represented one third party at first instance who is not, I would say,
Yes, who is therefore not appealing the appearance in this judgment of their information.
That's correct, yes.
I mean, they may want it to be in the judgment. I don't know. I mean, you may say, well, that's unreal because they obviously came along asking not to have it, but they also didn't appeal, so they can't have not wanted it that much. And for us to say, well, actually, despite the fact that you accepted the decision it was going to be published, we're going to take it on ourselves to not publish it. Feels a bit odd to me.
If I may
if
say
it
so,
really
my Lord,
does
I'm not
affect
sure that characterising the non-appealing counterparties as being happy for this to
We just don't know, do we? I mean, you're probably right, but we don't know.
indeed, but one can't make any implication either way.
I mean, on your first point, which is really the same points as we've been putting to both Mr. Campbell and Mr. Abraham, perfectly follow the point. I mean, if it's deleterious to your position or your respective positions, then everything should be redacted. That's fine, but your second submission does, as my Lord says, is a bit more troubling.
Just to make the point clear, what I have in mind, and I think it's what my Lord is thinking, is, for example, there's a table of numbers, but there's no total. The total is either not there or is redacted. Then the existence of a figure for, somebody X, company X, which isn't anyone in this court, and who didn't appeal, doesn't seem to me to be something that is within the scope of any of your appeals, or could be.
Well, my Lord, I don't have any particular need to achieve the effective protection of my client's confidential information, as long as it is protected, and that is the fundamental aspect. As my Lord says, if the total is removed, then that has that effect. But certainly that is something that we say this court has the power to do within the scope of both the grant of my appeal.
If the totals are taken out and the averages are taken out, the fact that there are other figures that are still there for people who aren't appealing is not going to enable anybody reading that to work out what your figure is.
Well, my Lord, I'm not pressing back against that where that is manifestly a practical solution to this problem. But I should make clear that my third and final submission, if I'm wrong on both of the two submissions, is that I would seek permission to amend my ground. There are 2 points in relation to that. The first is that my client could not have known about this at the point that the
it's the same point.
it's the same point. I don't know if it would be of assistance, but I have in fact got the judgment as it was sent to one of my clients, Google, from which my lords will see what we in fact have, which I think is useful. I wonder if I might hand that up. Sorry? You can see it. And my lords, if you just flick through like a magician with a pack of cards, you'll see that there are various pages intentionally omitted. So the first point is that this is not a complete judgment. So this is after the consequentials hearing, and the judge had made his decisions on confidentiality. This is what we were sent. And if my lords could look at internal page 243, here we see table 10, which is the crucial table, I think, for the from the point of view of the discussion Lord Justice Birss was having earlier with Mr. Campbell.
So internal
243,
243.
my lord, is the start.
Oh yeah.
And the point is that, yes, it is quite true to say that there was a box which had total rate, or a number of boxes with totals set out at the bottom. But equally crucially, all of the other rates were redacted. There's no distinction drawn at that stage, and this is after confidential, the confidentiality hearing between parties that are still maintaining confidentiality, parties that haven't decided not to oppose it, and so forth. And yes, with the benefit of hindsight, one might have started to try and analyse this table and said, oh, well, what if these people don't appeal, and what if those people weren't there, and so on and so forth, and how many of these black boxes does one strip away, and what is the consequence once one has stripped away all of those black boxes. But this was what we were faced with at the point when the grounds of appeal were met. So, my lord, that would...
And actually, interestingly, is this just a slip? Most of the totals don't even have a... Although in the version of the judgment that we've been given for the purpose of this appeal, which you haven't seen, is to what? In which all the numbers are there, but they're coloured in different ways. And we've got blue colouring for numbers which are the ones which the judge said he would not redact, but are subject to the order, which is still under appeal.
Yeah.
All of the totals and averages in that table are marked in blue for us. So, for example, the number, I won't read it out, the number at the bottom of the page, where it says average ad valorem rate for 1% of the stack.
Right, I had that in black. My lord.
Two numbers there.
That's in black. I can't see that, so...
Sorry, the thing
Oh, no,
you've
sorry, I
just
just
handed up to us.
Yes, sorry.
On page 244,
Yes,
the bottom row
yes,
says average ad valorem rate for 1% stack,
yes.
and there are two numbers there
Yeah.
that you can read, and the one you've just given us.
Okay.
Oh, no, I'm glad to see I've got a different one from you.
Yeah.
I'm glad I asked you.
Yes, well, indeed. And I can tell my lord why this has arisen, and that's because there were two in our haste to print out the judgment that we were sent over the lunch adjournment. I was sent two versions, one of which is a black and white version, and one of which is a coloured version. Lord's talking about the penultimate row from the bottom.
No, not penultimate, the ultimate, the bottom row, on page 244.
What you just handed to us,
Oh, I'm so sorry. Right at the bottom. I was looking at the wrong
No, no.
column. I do apologise.
there are two figures there.
Yes. No, I'm so sorry. I thought you were looking at the next rise. Yes.
There are two figures.
Two figures. The
Yes.
point is, in the version of this same table that we have in the judgment we have for this appeal,
Yes.
those two numbers are in blue,
Right.
which indicates to us that they are numbers which the judge is refusing to redact, but we wish to leave open. But that depends on what happens to the order.
Right.
But according to this version that you've been given, you were being told that this wasn't going to be redacted.
Yes. Well, that again is
And the
just.
same goes for the third one up, Optis average annual order.
Yeah.
And the total rate, and the,
Yeah.
So that's extra.
My Lord, I'm going to come on and address my Lords on a Google specific point, which relates to some information which we hadn't asked the judge to redact, which reveals our unpacked rates, for the simple reason we didn't know about it at the consequentials hearing. And after the consequential hearing, we discovered that in fact there was some further information that had not been previously revealed to us, and that is part of the appeal. And I'll come on and address my Lords on that point, because I need to. But that simply illustrates the fact that as the scales were lifted and more information was unveiled to us, where we saw information which did threaten our underlying confidential information, we raised the point as soon as we can. This was a situation where, until very recently, we were completely unaware of it. And so that would be my plea for mercy in terms of amending my grounds where that necessary, my Lords. The second point is no prejudice results from that. And on that point, I would just raise one particular point, which is in the consequentials judgment, my Lordships may remember that the judge specifically set out in his judgment, and this is at paras 56 and 57 of the judgment, which my Lords will find at Core Volume 2 to page 465. The judge, concerned with the fact that all of the parties were in the same boat seeking to redact material and there was no adversarial process, essentially sent out a challenge to the world saying, look, if anybody thinks this stuff ought to be made public, then I'd welcome your intervention on this. And he adopted Dr. Nicholson's suggestion that there be express liberty to apply, and of course nobody has emerged, and so, my Lord, were the scope of our appeal to be changed, I would pray and aid that as showing the absence of any prejudice. My Lord, if I can just turn to the specific information of my clients, and if I can do that by reference to Annex 3, so back in Core 1 of the judgment, 10 on page 420.
Yeah.
My Lord, my first client, Huawei, that's the first license on the list, and obviously the yellow figures are the lump sum figures which will be redacted. Now, my Lord, this is the oldest license, and although my learned friend addressed you very briefly on the date of the material, I do want to show you some particular passages of Unwired Planet, just for the context of that date. So, my Lords, if I can just ask you to turn up the Joint Authorities tab 12 at page 680. So this is my Lord Justice Birss's judgment in Unwired Planet confidentiality, which you've looked at, but I just want to make a particular point about the dates. And if my Lords could just look very quickly at paragraph 34, very, very extensive redactions were sought in relation to all sorts of information at that hearing. And in this action, my clients, notwithstanding that they believe there's quite a large amount of different aspects of licenses that are confidential, have limited themselves for pragmatic purposes to the crown jewels, to the unpacked rates and the lump sum.
Sorry, I'm now lost as to which page are we
I'm
on?
so sorry, my lord, if 679 of the bundle,
Right.
does one see 34 at the bottom? As mentioned already, the redaction source are less extensive than those in the 711 judgment. There's still substantial, about 800 paragraphs. Redaction source about 130 of them. So they're a very wide redaction source. And in terms of date, I just want to turn to paragraph 41. Paragraphs, some numbers set out, relate to details of the 2009 Ericsson Huawei license. So again, a license that at the time was 10 years old, older than the Huawei license issued here. I have accepted proposed redactions sought by both Ericsson and Huawei. Those redactions remove the specific figures. So the figures, the license figures, which is what we're talking about here, were redacted. However, Ericsson sought wider redactions. They were not opposed by Huawei, nor were they supported. The reason I reject is that this license is historic. It was signed in April 2009 and so on. Ericsson's evidence did not persuade me by revealing these aspects of the terms, i.e. the wider things about the license, was really damaging. And my lord, so I take 2 points from that. The mere fact that a historic license, a license is historic, is not of itself the basis of refusing the redaction of figures. It may well, though, be a basis for redacting wider information about that license, the names of the parties, the date it was signed, and so forth. And my lords, that is not surprising, because ordinarily, if a license forms part of a FRAND analysis, it is because it is relevant to the current dispute, not because it no longer is. There are exceptions, and in the judgment of InterDigital and Lenovo, I won't take my lords to it, there was a particular license, the RIM 2012 license, which for different reasons had rates which were no longer confidential, of which one aspect was age. So, my lords, that's the oldest license. The second, my lords, still on Annex 3, if you still have that open. If not, it's core 1, the last tab. If one turns through to 423, in the first full row, my lords, that's the LGE license. And one sees that is more recent, and indeed only expired in 2022, so only a couple of years before the license. And if my lords, I can just draw attention to the second column, under the heading LGE 2007, there's a blue box containing some words. And those words are wrong, and manifestly so on the face of the judgment. And I'll come back to that, my lord, because that is a mistake, not dissimilar to the mistake raised by Mr. Campbell.
So you're talking about the LGE row.
The LG, yes, LG row,
Second column.
second column,
I see.
yes. There's also some blue wording in the final column. That's nothing to do with us. That was raised by another counterparty, and as I understand it, is no longer advanced. And then, my lords, just to finish the set, at page 425, at the bottom, this is the Google license. And my lords, this is still current even now, and in that respect, I obviously adopt the comments of my old friend Ms. Abrahams as to the impact of that on the importance of that as confidential information. So, my lord, I don't intend, obviously, to repeat any of the submissions my learned friends have made about general principles, and I respectfully adopt them and endorse them. But there are two specific points that I do need to raise that relate only to my clients. And the first one, as I've indicated in relation to LGE, is a very simple one. The information I've just shown you is wrong, and one can see that from the judgment itself. If one goes to 398, here more detail is set out about the licenses. And if one looks at little letter E, one will see the information from which one can happily conclude that the summary in Annex 3 is wrong. Now, my Lord, this was the matter, the subject of submissions below, both in writing and orally. Naively, I suggested to the judge below that this was unlikely to be controversial. My Lord, it plainly satisfies each limb of the test he set out at paragraph 25 of his consequentials judgment. It's plainly an error, it's immaterial to the judgment, and it can be easily achieved just by deleting the words in Annex, leaving them redacted. My Lords, I'm unable to help, my Lords, as to the reasoning and analysis of the learned judge, because it just amounts to no. It's impossible to understand what the basis is for refusing to either just delete this or redact it, and we say that is both unfortunate and a matter that this court should and can correct. My Lord, the next point is on Google, and it's a point that follows from the matters, the subjects of the appeal, but it does require a short explanation. And if my Lords could just look at the judgment at para 470, which is at page 391. When I have subpara 3 at 391, he turns to the Google license. There's a lump sum figure, which is obviously a redacted figure and is going to remain redacted. But then there are three subparagraphs A, B, and C. And in these are figures from table 10. And my Lords may recall that table 10 is where the unpack rates have been normalized to 1% of the stack. And so what one has is two figure 10 figures in the first line of subpara A, and then for me there's two redacted lines underneath that. I don't know what they say. And then at the end of B there is another figure given, which is a percentage figure, but it's a percentage figure relating to 100% of the stack, and so it does require some reverse engineering to get back to the figure 10 figure, but it is just dividing it by 100. Now, my Lord, since those are just essentially direct unpack rates, we say they follow from the appeal. The reason I raise this is because Google did not, before the judge, raise these figures. And the reason they did not is because they had no idea they were here. So, my Lord, the whole of what happened is when the parties received the draft judgment, they provided extracts to each of the relevant counterparties, identifying those counterparties as confidential information, and those extracts were themselves redacted. Google received extracts from the draft judgment. The whole of 473 had been blacked out because at that stage some other party or counterparty, we don't know who, was making some submission in relation to it, and so Google saw nothing of this.
Sorry, Mr. Ward, the version you just handed me, which was the extract that was sent to Google, it's all in it.
Yes, my Lord, and that is because that is after the consequentials hearing. And my Lord's ahead of me, in a sense.
Yeah.
After the consequentials hearing, we received that, my Lord, and there were the numbers which in fact were unpacked rates. So, my lord, at that point,
So the sequence is, there's a draft judgment you received where you don't see any of these figures that we're
Yes.
looking at in
extracts from
paragraph
the draft structure.
470, because it was completely blacked out.
Correct.
Then there's the consequentials hearing, which is that the one you were allowed to go to, or the one you weren't
That
allowed
was
to
the
go
one we were allowed to go, my lord.
Okay.
I submitted the unpacked rates of Google should not
Then
be
after that,
published.
you get this.
Yes, my lord.
And then the second consequential hearing is the one you weren't allowed to go to, December one.
That, I think that would have, and that's right, we weren't allowed to go, but I think that preceded the hand down of the redacted judgments. I think that may have preceded. I'm afraid I can't tell, my lord, concretely. But
well.
what we do say is that what happened is the solicitors for Optis, who were trying to deal with this monumental task, and this is not at all a criticism to them, this was a nightmarish task, when whichever counterpart it was stopped advancing its position, it unredacted everything, it did not spot these points. We pointed them out, and they said, okay, we'll have them redacted. Crucially though, my lords, this material did not go either to the public or any other counterparty. So it has in fact remained confidential, and I appreciate it's a rather tortuous exercise, but I felt it important to explain to my lords that this information, although obviously it's confidential for the same reasons as my lords have heard extensively today, was not something we raised with the judge, and that is why. My lords, unless you have any questions for me.
My lords, as your lordships will have seen, both myself and for that matter, Optis, I represent Apple, are not opposing any of these appeals, and we aren't taking therefore any position ourselves. Our role in respect of confidentiality, as it has been all the way through these proceedings, is to try to assist from the perspective, the wider perspective we have, because we in the court are the only people who are able to see everything. Now, as your lordships may well have picked up, confidentiality in this case has been a monumental effort that's been going on for a number of years. Your lordships are seeing the tip of the iceberg. At various stages through the process, there has been as many as I think 37 counterparties, all of whom have had to be liaised with at various stages and when a wider quantity of confidential information was in process through the court. What it has meant is that at every stage, when a document such as a draft judgment or something of that nature has been produced, Optis has looked after its counterparties, Appellant has looked after its counterparties, and we've liaised between ourselves. We've largely ended up having to produce 37 different marked up versions and send them individually to whoever's representing the relevant people, trying to correlate what happens with the actual material. And as a consequence of that, there are, I think, two issues which we've sought to draw to your lordship's attention in the note, which unfortunately we were only able to provide at the beginning of the week. One is the issue of unintended consequences, and the second is one of consistency. The version that your lordships have in Core 10, having heard my learned friends and looked at their submissions in writing as well, I believe that everything that's highlighted there in blue is the full set of information for your lordships to consider on this appeal. What we have sought to do, looking at all of the possibilities, is maintain as marked up and therefore as confidential material which might cause a problem of unintended consequences. And just to give an example of that, we don't know yet who would turn up this morning actually present in court. We don't know how your lordships will, for example, approach unpacked rates. You might decide to follow the unwired planet Lily ICOS. You might look carefully at the balance for each individual appellant. And you might decide that only one appellant has made good their unpacked rate as being confidential information. In those circumstances, the totals become of critical importance, because with only a single redacted line in the table and then the total at the bottom, it's very, very easy to backword the data. The more that's redacted, the different combinations as to what is redacted gives rise to the different possibilities. And what we've sought to do is to maintain confidentiality on all the permutations we can see, and in the schedule to our note, explain why the individual lines have been redacted, so that hopefully your lordships can work through them and have an understanding of why each point is an issue. The second issue is one of consistency. It is very readily apparent that only a limited number of counterparties has made it as far as this court. Where we have had a clear statement from a counterparty that they are prepared for their information to be made public, we have made it public. So, for example, one sees in Table 9, there are figures for unpacked rates. Yes, so I'm just looking on, yes, Table 9 on 386. The last 4 unpacked rates are not marked in blue, because we have been told in terms that those parties are happy for those figures to be published. Otherwise, we have maintained them. And
So just so I understand that, let's just say, looking at page 386 as an example, and what we've got on 386 is, I think, a total of 6 sets of figures that aren't in blue.
yes, my lord.
So that those parties are prepared for their information to be made public. But nobody else has indicated a willingness to have their information made public.
They are,
So if picking up on the picking up on the point that we made to Mr. Campbell and Miss Abraham, if we were to take the view that the prejudice point, and everything that's currently in blue should be redacted, and if we accept one or other of the ways in which they've argued that point, as in terms of whether it's within the appeals or not, if we accept it is within the appeals, or if somebody wants to file an amended appellant's notice, they can.
yes, my lord.
All of that. Does the existence of the 6 unredacted figures, you may not be able to answer this, give rise to any potential prejudice to anybody, or is it just such a small percentage of the overall, on the assumption the total gets any totals, and there isn't a total in this one, but there is in some of the others, that any total gets redacted? It's just not possible to work out what anybody else's figures are.
There is, on that particular question that your lordship has raised with me, the issue does arise, and it arises because separate totals are given in table 10 for Optis counterparties and Apple counterparties. And what your lordships would see if you were able to drill into it, and it's not apparent on the face of the table, those figures that are released, I think all of them are on the Optis side, leaving predominantly Google and I think 2 others of, you know, the identity. The other 2 are, they're relatively small entities, contributing into the average Optis rate. So you can get very close to the average Optis rate, even with those publicly available figures. But those figures have been published as headline rates. They're out there in public. There's nothing we can do with them. We can't ask your lordships to redact them.
No.
But otherwise, the other issue, apart from the unintended consequences, which does lead into some of these figures, is the issue of consistency. The challenge, in many ways, the challenge that is being brought by the appellants about specific redactions in the table. It's about the judge's underlying approach and analysis and the law that he sought to apply. And one of the options, and I put it no higher than that Apple and Optis sought to leave to your lordships, is that if, having reviewed on the basis of the individual appeals, the judge's analysis and conclusion that unpacked rates should be published, if your lordships decide that they shouldn't, they should be redacted, then we say for consistency and to make the overall process as a whole complete, it is right, or your lordships should have the opportunity at your own motion to apply the same finding for consistency to those who, for reasons we don't know, maybe because they can't afford it, maybe because they've already spent something close to the £250,000 that you heard this morning that some of the other counterparties have spent, trying to deal with confidentiality in these proceedings, which they're not themselves parties to. For one reason or another, they have not come themselves before this court. But if your lordships decide that the judge below shouldn't have published their unpacked rates, then we at least wanted to afford your lordships with the opportunity to direct that the markup, in accordance with a judgment, if in favour of the appellants, can be applied consistently and generally. Now, what we've sought to do, now I should say that a lot of the unrepresented counterparties are counterparties to my client, Apple. So my client technically has an interest in the figures as well. My client has chosen not to appeal to date. But if as a pure matter of procedure, as was raised by my Lord Justice Arnold and the Chancellor this morning, if as a pure matter of procedure, the fact that nobody is appealing the figure leads to these matters being published potentially at relatively small parties contrary to their interest, then my client is prepared to ask for permission to appeal to say mutatis mutandis in respect of their figures, so that your lordships have a procedural mechanism by which their interests can be taken into account by this court. We respectfully say that ought not to be necessary. Even under the Trade Secrets Directive, in Article 9, it includes provision of the court by its own motion. And for consistency, we would invite your lordships to take that forward. Now, against that
I'm sorry, can I just ask a question? The party that I'm struck by is Ericsson.
yes, my lord,
Because it doesn't fall within what you just said. They can carve themselves perfectly well.
they are a big party, yes.
They're a big party. Their numbers are all over this. They're not here. But I don't understand why it would make sense. I don't know if they were before the judge below. Funny feeling they might have been.
They were, my lord.
I can't really see why, other than for the reason that Mr. Ward articulated, which I completely, not only Mr. Ward, I'm associated with in particular, but the point of if you can derive information about Mr. Ward's clients, say, from the totality of information, that I completely understand.
Yeah.
But if we're not doing that, I have some difficulty with the basis on which we should be doing anything to change the circumstances as they were when Ericsson decided not to appeal, as far as Ericsson's numbers are concerned.
My lord, the difficulty I have with that is I have no idea why Ericsson isn't appealing
I
either.
understand that, but just to put it to you directly, you've just made a submission to us that effectively invites us to do exactly that. Not. That's what you just said. You said we should do that.
My lord, I don't know why they're not
to
appealing.
start amending, putting in respondents' notices, even though, as far as I can see, your clients have been assiduous not to do that. So that's why I'm raising this question, because I don't fully understand the basis for it.
Yeah, my concern is, my lord, is that we don't know why Ericsson's appealing. Whether or not they have liaised with the other those who are appealing, that they believe that the issue of unpacked rates is before the court. Now, your lordship may say, well, you can't ever rely on some other appellant going. but it is not apparent why they objected below. They haven't consented to the publication of their information, and they are aware that this appeal is taking place, and other parties are challenging the constituent paragraphs of the judgment as a matter of generality. The difficulty that one might otherwise end up with is, well, it's not 37, but it's certainly 19 or 20 parties turning up represented, all saying the same thing. Now, it may be, I don't think it occurred to anyone before this morning that the court might have a concern that the approach wouldn't apply mutatis mutandis, where the same point was applying to the same data. Now, it may be that collectively, between the represented and the unrepresented parties, we could have analysed it differently and come to a different conclusion. But I don't act for Ericsson, but I'm suggesting that there is as much concern about assuming that Ericsson is content for this figure to be published. And remembering, of course, that Ericsson is free.
I'm not assuming that they're content for it to be published.
But,
What I'm doing is saying there was a hearing about it, they lost on this point, they have an appeal,
That is true, my lord.
and they can look after themselves.
Your lordship.
I mean, obviously, if the other point is right, about the impact on those people who are appealing, that's a different issue altogether. But
Yeah.
I mean, if it's not right, then I share my lord's concern. And Ericsson's quite a big player in all this, looking at what we've got.
I mean, just to be clear, I'm not picking on Ericsson, I'm just using the fact
No,
that
Yeah, I mean,
there's a
there are
large
others.
party who isn't
Yeah.
represented.
There are others as well.
I understand entirely your lordship's concern, and that's why I say, if absolutely necessary, I can abridge that by saying the party with the Ericsson license is Apple. Apple, my client, has as much interest in the Ericsson license as Ericsson does, and if, as a matter of formality, I need to ask for belated permission to appeal, to run the same points on the same data against the same paragraphs of the judgment that your lordship has already heard,
Yeah.
then I've obtained my client's instructions and they're prepared to do so. Because we certainly as well had understood that that the point was in issue, maybe wrongly so. My lords, your lordships have the schedule, and I don't think I've got anything I can, unless your lordship have got any questions.
I have one question.
Yes.
And your schedule, this is the schedule, all the same schedule, the figure next to your Appellant Optis joint note.
Yes.
The first entry, which I think uses, I don't think it's confidential, uses the word license structure.
Yes.
That seems to me to be a bad point here. You're making a point of consistency because you say InterDigital is appealing about some text which I could characterise as licensing structure. And you say, I understand, well, if that's being redacted, so there's lots of other licensing structure and that can be redacted too. But the basis for InterDigital's appeal is that it's wrong. Not that it's confidential because it's licensing structure, and that doesn't apply to any of the other points. So I don't understand this submission.
I understood on that one, my lord.
Actually, formally it is both. We say it's confidential and it's wrong. Although I spent more time on the and it's wrong. Sorry.
So, it, that is the reason it's highlighted. And, you know, I emphasise, again, my lords, it's not a case of my client arguing for these redactions to be made in the way this is put forward. It is to draw to your lordship's attention that there is a decision for you to take as to the confidentiality of licence structure. And we've pointed out the licence structure points elsewhere where they occur in the judgment. And the most we can do is to say to your lordships, if you're considering licence structure and you go with in this case, InterDigital's appeal, you may wish to consider this license structure issue on one of the non.
Just to finish that thought, as it's in my head, and maybe I'm not addressing the right advocate, but if I remember rightly, if you replicate the approach that was taken in the Unwired Planet decision, this wouldn't be redacted.
I couldn't give you a clear
Because the
answer.
Unwired Planet decision redacted figures and not other terms from licenses.
I think your
Shown
lordship
that-
is right
shown
in.
that by someone earlier on.
I think your lordship is right in that. What I don't know about the Unwired Planet decision is whether or not it was ever argued, or firstly, whether the court was ever intending to publish issues of license structure, and secondly, whether it was argued as to whether they should or shouldn't. I would have to.
Well, it was argued that there were other terms, because that's the bit of the judgment. And by the way, I'm not doing this on memory, I'm doing this from what's on top. Because oddly enough, I don't really remember. You may find that hard to believe. But the judgment that we were shown, the decision of the judge in question, was to redact figures and refuse the application that was made to redact other licensing terms.
That may well have been the case.
My lord's referring to my submission in relation to paragraph 41. That's quite right, but that is specifically in relation to the Ericsson license, which was an old historic license. So my lord is right that other terms weren't redacted. What I don't know, and I can't answer, is whether other licenses that were more current had different positions taken.
Okay.
My lords, unless I can be of any further assistance, that's all the normal
Just a moment.
has got to say.
Sorry, Mr. Nicholson, we do think your client should serve an appellant's notice on this point.
An appellant's notice.
Because apart from anything else, if you appeal it, the overall point of principle, then it addresses the issue that my lord raised with you about
I'm very
those
grateful.
people
my
who
lord.
aren't appealing, otherwise appealing.
It is Wednesday today. I'll follow it in the next 24 hours.
Thank you. Mr. James.
Lords, very briefly indeed, I adopt my learned friend's explanation of the markup and how that's been produced by the solicitors for Optis and for Apple. One point of detail that I think I should make just by way of clarification, on page 387 at core 1 tab 10. The numbers towards the bottom of the entries of rows for licensees, the Optis licenses that are in the clear. They're in the clear because they're deals done at Optis's headline rates, which are published, and so those numbers can't conceivably be confidential. It's not accurate to say it's because those parties have consented to that information being made public. Next point of detail, my own friend Mr. Ward's handed up a version of Annex 2 that was provided to his clients after the consequentials judgment. I haven't got a copy of that. I've spoken to my instructing solicitors. As I understand it, the point raised by Lord Justice Birss, that some of those numbers, the totals, are in the clear in that document. That will be true of every version of Annex 2 that has been sent to every counterparty. I can't say specifically which totals are going to be in the clear in which document, but there will be at least some totals and some averages that are in the clear in every version that has gone to every counterparty. So there's a bit of putting the genie back in the bottle on the totals. It may be that the only solution can't be by redacting totals if they've already been provided to people in the clear. If your lordships need more detail on precisely what was provided to each counterparty, we can of course get that together.
I doubt whether we'll need that.
My lords, the final point is my learned friend's suggestion that he will ask for permission for appeal and the indication from your lordships that you'd like him to do so. My lords, we're in a slightly different position in that to that my learned friend, in the sense that the only counterparty that might be affected by this point about totals and what can be derived from totals in combination with the rates for other parties is Google. Mr. Ward's here for Google. If he needs additional permission, he can and has already asked for it, so I'm not in a position that I need to do so to ensure the request is made before you. Unless I can help further, they're the only short points I needed to make.
Thank you very much.
Well, I could just say a few things in reply to that. If Lords would find it would be helpful, I'll just say what I was going to say. If anyone else were to obtain permission to amend the grounds of appeal, that was successful, we would make the same application for the same reasons. Having said that, if Apple are going to do it, I don't think we actually need to. That was
Okay.
all I proposed to say.
We can do that by the end of the week, lovely.
I'm grateful. Thank you, my lord.
Okay. Anything else want to say anything? No, thank you very much. Right, well, thank you all very much for your helpful submissions. You obviously reserve judgment, no promises as to when you'll get it. In other words, no promises whether you'll get it before the end of the month. Seems unlikely. But we will let you have it in draft as soon as we possibly can. Will you please pay attention to the terms of the embargo on the face of the judgment, and provide us with any typographical errors and the like, not with invitations to reconsider our reasoning. And if you can agree a draft order to accompany the corrections you send us, that would be very helpful as well. But once again, thank you all very much indeed.
So rise again.